Thank you, Your Honor. I think at the outset it's important to recognize that everyone's doing their best here. The court is, I know the clerks are, I think the media is, we certainly are, and the defense is. This issue came up in the context of an examination of a witness. One exhibit was published. Before the exhibit at issue was also brought onto the screen, I explained what we were going to do, and then the exhibit was brought onto the screen. I reviewed the video last night. The camera captured this for approximately 2 seconds. The camera operator, I think acting in diligence and appropriateness, immediately panned as soon as she realized that there was a new exhibit on the screen. The court took it down. As soon as they realized that an exhibit was on the screen, I immediately instructed my paralegal to take it down, and it was.
Right away, you can see the prosecution isn't denying the mistake. They're framing it as a fast, good faith error. That's a smart legal strategy. Courts often look not only at what happened, but how quickly everyone acted once they realized something went wrong. But here's the real question. If a restricted exhibit appears online for even 2 seconds, is the damage already done? Let me know what you think.
Defense, I think everyone involved here made quick and appropriate efforts as soon as they realized a mistake had been made to remedy and mitigate that issue. As I explained what I was what we were going to do, defense counsel did not object as that happened. And the reason I bring that up is because of the requirement for timely objections. Moreover, I do want to say this exhibit was read into the record. It was allowed to be read into the record earlier.
This is an important judicial moment. Notice how the judge isn't rushing to assign blame. Instead, the focus is on creating an accurate record before deciding on any remedy. That's exactly how courts try to ensure that any sanction is proportional to what actually occurred, not just how emotional the issue feels in the moment.
Evidence and published to the media. Finally, we are going to be dealing with a lot of publicity when it comes to media coverage, and I think that's really where the remedy is going to be addressed. I understand there may be a remedy that can be fashioned today to prevent this kind of thing going forward or going on in the future in this hearing, but I think ultimately that's where this will be addressed. Any other questions from me, Your Honor?
Well, not at this time. I will afford you the opportunity, obviously, to respond when defense comes back. I want to weigh this and taking in consideration, and I find your representations to be accurate as to what occurred. I believe that I noticed it and asked for it to be taken down because I have a live stream on my screen for that very purpose. And the sequence, I believe I made note, and if I'm wrong, please correct me. It's been a long 4 past days, but that's the only addition that I find to the representation. And certainly, Mr. Novak, feel free to correct it if you believe the sequence was any different. I just want to make sure a clear record is being made of what happened in order for whatever happens next to be appropriate and proportional to the actions that occurred.
No, and that's consistent with my memory, and I also reviewed the video, the live stream as well, in preparation for this issue today. So that's exactly what I think happened. From my perspective, examining the witness, I did not have a view of what was being published to the public and the media, and so I think the court immediately, as soon as it recognized that, brought that to everyone's attention.
Thank you, Mr. McBride. To the media.
Good morning, Your Honor.
Good morning.
Appreciate the opportunity to be here to speak on behalf of the media. I think our understanding of what happened is consistent with what both the defense and the state have said here. So I don't want to belabor that point. But here's how I understand them. There's 2 exhibits at issue. Those exhibits
Now the media's attorney
were used
introduces a
yesterday
modern
in
courtroom
part because
dilemma. Everyone may
juxtaposition of
have
those two
followed the
exhibits might have
process as
provided some sort of
intended,
benefit to the
but
court.
technology changes
The first
everything.
of those
A
exhibits,
single screenshot can spread across
was
the internet in seconds, making a brief
asked to be
mistake
published
potentially
through
impossible
all
to
three of the
undo.
court's phases.
It's a
The court
reminder that
said
today's
it will be admitted
courtrooms
into
aren't
evidence,
just dealing
shown
with
in the courtroom,
evidence.
will not be
They're
shown on
also
camera.
dealing with the
That happened about
realities
3
of
hours
the
into
digital
hearing.
age.
That all went smoothly and well. That operated exactly as it is intended to. That requires the participation of everyone, the court, the defense, the state, media, camera operator, all to do that well. Later in the day, when in the video I reviewed, this was about 5 hours into the runtime yesterday. The second exhibit that was going to be compared side by side was introduced. That also went through that 3-step process. In that case, the court said that that could be admitted into evidence, shown to the court, and then also shown on the cameras. So it was put on the courtroom cameras. At that point, there was what I think is a useful practice by the camera operator to wait a beat, because sometimes mistakes do happen, right? In that case, though, that was authorized. So the camera then panned to the screen, which is set up specifically for the camera operator to be able to capture that. Examination on that exhibit began. Then, because the examination seemed to call for that juxtaposition, without much warning for anyone involved, the previous exhibit that was intended to be juxtaposed was placed on the screen. From, I think, a observer's view who didn't know where the testimony was going without warning. The camera operator, I think quite astutely, within seconds, recognized this is a different exhibit. And recalling the court's prior order, recognized I should pan off, and did within seconds. I think at the time that was happening, the court also caught that and said, let's not do that. Now, and that was the end of it. I think the 2 seconds is about right. I don't want to minimize that. I understand the point that Mr. Novak is making. We are operating in some ways on high wire. And we are trying to place as many nets as we can, and all the parties are working together to try to do that. But in the age in which we live, one of the challenges is that sometimes when something like that is placed on a live screen, someone can screenshot it, and like Mr. Novak said, if they want to put that for sale on the internet, then they can. That's why working together to ensure that
Here's something worth paying
small
attention to.
mistakes like that
The media
don't happen
isn't
is critical.
arguing that the
And the
court's
media
order
has full-
didn't
the
matter.
media
They're
coalition
acknowledging the
that are
order
given the
should have been
opportunity
followed,
and the
while also
benefit
pointing
of
out
being
that
able to be
much
here
of
to
the
run
information
cameras and to
was
take
already
photographs
publicly
have complete
available.
buy-in on
That's a
that.
subtle but
There are, of course,
significant
people out
distinction
there
because the
watching
legal
the live
issue
stream
isn't
that are
just
not
about
part
the
of our
content.
coalition
It's
that we
about
can't
whether a
control,
court
and that's why
order
it's
was
so important
violated.
that we get these pieces right. I do want, without going too far into the evidence, to note not only that several lines of this exhibit are available publicly in the information, but that the full text, every word of that exhibit is contained in a search warrant, in this case, that was initially filed on September 17th. This is in the 4th District, but in a different court. Was held for 6 months, as search warrants often are, but then on March 17th, March 16th, March 17th, was released in full. On page 7 of that search warrant is the full text of this exhibit. I don't want to suggest that anybody gets the right to say, well, I think it's public. The court has said don't show it in the screen, but since I think it is, we'll just come back later on and tell the court it's not a big deal because it's already public. That's not how it works. If we say we think it's in the public, the court says, I understand that, but I'm going to make an order. That order should be adhered to. But I do, for purposes of prejudice, for potential remedy, for the court's concern and the court's sleepless nights, I do want the court to know that as well. And members of our coalition have pointed out to me as we've talked about this, while we take this very seriously, it is true in this case that the full text of that, not the image of the exhibit itself, but the full text is already in the public sphere, has been reported on, and is out there. I only want to reinforce, to close,
The defense now shifts the conversation from how long the exhibit appeared to the lasting impact of that appearance.
Recognition that
Their argument is simple.
the media,
Once an image
our
reaches the
coalition,
internet,
I,
it can
as an
exist
attorney for
forever.
that coalition,
Whether that
have an
justifies
obligation to make sure
sanctions
that
is
mistakes don't
ultimately
get
for the judge to decide,
and in this
but it's a
case, even though
compelling
I
point in an
believe
era
the
where
camera
digital
operator
evidence can
didn't
spread
act in violation
instantly.
of the court's decorum order, didn't do something that was forbidden by that there was an order that said, don't publish this exhibit. And because it flashed on the screen when the camera operator was filming that screen, that did happen. The media is fully bought in. I, as one of the attorneys and the other attorneys for the Media Coalition, are fully bought in on a goal to make sure that this kind of thing doesn't happen. Of course, I understand Mr. Novak and the defense's need to make a record and make an objection, and I also recognize
And just before the
appreciate and
recess,
understand
the
court's
defense
goal
raises
in trying to
one
make
final
sure
factor.
it
They claim this
imposes
isn't
whatever
the
sort
first
of
time courtroom
direction,
restrictions
caution,
have been
sanction,
breached. If
response
that's
that it
true,
believes is needed
prior
to make
incidents
sure
could
that
influence
its
how
orders
seriously the judge
are
views this
recognized
latest
and adhered
mistake.
to.
Now
We want
all
the court
eyes
to know
turn
that
to the
we will
court's next
understand that
decision.
we'll,
Will this be treated
comply with
as an
whatever it is the
isolated
court
error or as part of a larger pattern?
Anything further before we break? Mr. Novak?
We don't need a break.
Okay. Well,
The court wants a break.
I want to review this. I'm sure there is a stream out there. I want to look at it again in order to appreciate the full effect and exposure. I remember it, but given the nature of this and trying to weigh the constitutional rights of all parties, I want to be thorough and look at it exactly. So as we move forward, as I evaluate what's being requested by the parties, that I am at the level of knowledge, and because for what it is, it was on screen. I want to look at it, how long, what exactly was on screen, and in order to be at the point of saying, okay, I fully understand. I mean, I was here, I saw it, I noticed it on the screen, but again, I want to take that extra 2 minutes to review that.
I am not suggesting that we rush through this at all. I just wanted the court to understand that our request for the remedy and the sanction, we are prepared to share that with the court, but we can certainly wait until the court has had an opportunity to review whatever the court thinks it needs to review. The permanence of this violation of the court order is a different issue from how long it took to correct the violation. It's a permanent consequence. In other words, that image is out there forever and ever in violation of the court's order, no matter what actions the court, the state, and the media took to remedy it, because that's the technological world we live in. So that's my response, if I may, to the arguments. But we can hold our suggestion until the court's ready for it.
All right. If the parties feel it'd be helpful to confer while the court is reviewing it, you may, just so that if you choose to, I encourage it. If you don't, I respect that. A court's going to take about 5 minutes. Again, I just want to review it, to be brought up to full speed and just to have it freshly in my mind.
I'm going to make one more point, if I may, and that is this is not the first time that this has happened. We had earlier proceedings in this case where the cameras depicted images inside the courtroom that the court had prohibited, and the court imposed certain consequences on the media as a result of that. And so that's just something to keep in mind, in my opinion, if I may. Thank you.
All right, before the court takes a 5-minute recess and to review this, does any party need the benefit of the record based off the dialogue between me and Mr. Novak?